In this video, I'm going to go over your rights as a DUI defendant. First of all, in Pennsylvania, a DUI is a criminal charge. It carries a criminal record if, in fact, you are convicted of the offense. And depending upon what number DUI it is, will depend upon how serious the offense is. A first offense is a maximum of 6 months in jail. A second offense can be a maximum of 5 years in jail. And a third offense can be a maximum of 7 years in jail as a felony 3. The first offense, because it is a maximum of 6 months, does not have a jury trial, but all the rest of the rights that I'm going to give you apply to all DUI cases. The first thing that you have a right to is to remain silent, and you are presumed innocent until proven guilty or until you plead guilty. That means that throughout the whole process, the Commonwealth cannot compel you to make any statements. You have a right to a lawyer. You have a right to a preliminary hearing. And a preliminary hearing is usually the first court appearance that you'll have. That's a hearing to determine probable cause, meaning, is there some evidence that you committed an offense? The Commonwealth, if you have a hearing, at a preliminary hearing, has the duty to call live witnesses, which you have a right to have a lawyer cross-examine. You can call witnesses and testify, but at that hearing, the magistrate judge has to believe the Commonwealth's witnesses. So most people don't call witnesses or testify. It doesn't really do any good. If the police officer said the light was green and you have 10 people to say it was red, it's green for that purpose. You have a right to make written or stenographic notes of the proceedings, and it's not a court of record, so they don't provide that automatically. And you also have a right to see the physical evidence that's offered against you, if any. They don't have to produce discovery. They don't have to produce all their evidence. What they have to do is to just show some evidence that, in fact, you were committed the offense and that you drove the vehicle and that either you're under the influence or over the legal limit of whatever you're charged with imbibing. The preliminary hearing judge makes two decisions. One, does the case go to the higher court? And then secondly, what is your bail? The judge sets bail at that hearing, meaning that the judge will probably set non-monetary bail, but they can set bail conditions such as the fact that you are not allowed to imbibe alcohol or drugs, that you show up for court, maybe get urine screens and things like that. They also then set a arraignment, a formal arraignment date. The formal arraignment is a date about a couple of months later where the district attorney gets involved, and when the time deadlines to request discovery and to file pretrial motions and the like begin. If you're going to go for the ARD program, you would advise the court at that time, and certain things would have to happen before the ARD program is granted. Each county has different procedures in regard to the ARD program. Each county has different ways that you get in that, and requirements and prohibitions. After the arraignment, you have 10 days to file for pretrial discovery and 30 days to file pretrial motions, such as motions to suppress evidence and things like that. A trial date would be set, typically a pretrial conference date. And then ultimately, if it is a first offense DUI, you would have a judge trial where the Commonwealth would have to prove your guilt beyond a reasonable doubt. A reasonable doubt is a doubt that would make a reasonable person pause in doing some important thing in their life, or pause in believing that a fact is true. That means that when the Commonwealth presents their case, they'd have to present live witnesses, which you could cross-examine. You could call witnesses, including expert witnesses, and present physical evidence. And ultimately, A judge at a first offense trial would have to not pause in believing that you drove the vehicle and that you're over the legal limit, or that you were impaired. And it's an or. You don't have to be impaired if you're over the legal limit or had illegal drugs in your system. You don't have to be over any limit, just have detectable amounts, as an example of right now, of marijuana in your system. That is as of today's date, which is November 19th, 2019. Ultimately, if the judge finds you guilty, then there are mandatory minimum penalties that they must impose. There's no discretion because you're a good guy or you've never been in trouble before. If you have a DUI and you're convicted, if it's the highest tier, it's 72 hours mandatory jail for a first offense, etc. That's another, penalties are a whole nother video. If it is a jury trial, you would have the right to help select the jury. It would be 12 members of the jury. That is for a second offense, highest tier or greater. You would have a right to exclude jurors because they are prejudiced or for whatever reason. You have a number of preemptory strikes. Ultimately, after the trial is done, all the jurors would be instructed as to the law, and all 12 would have to decide to find you guilty for you to be guilty. If one says, no, I'm not doing it, then it's a hung jury and you walk until they decide whether to try you again. If all 12 say you're not guilty, then you're done. You're not guilty. You have rights to appeal. If you plead guilty, those rights are very limited. They're limited to the right to limited to whether the court had jurisdiction, whether the court gave you an illegal sentence, whether you made a knowing or voluntary plea, and whether your lawyer was incompetent in representing you. Those are only things that you can appeal if you pled guilty. If you are found guilty by a jury, then there's a lot of possible appeal issues. So that's a basic summary of all your rights in the case. Each case is different. When I look at these cases, even on first offenses, and if it looks like you're guilty of the case, I look at the case to see if there's any defenses to minimize your penalties. My job is to minimize your penalties and advise you what is in your best interest to do that. Please call me, Paul Arrow, the DUI guy. Lawyers, judges, and prosecutors call me to ask me questions, so don't be afraid to do it yourself.